Good evening. This is Making the Case. I'm Yodit Tewolde. Tonight we begin in Brunswick, Georgia, where a jury has been selected in the federal hate crimes trial for the 3 men convicted of murdering Ahmaud Arbery. Of the 12 people selected for the jury, 8 are white, 3 are black, and 1 is Hispanic. Opening statements also began today. Gregory and Travis McMichael, along with Bryan, are not only being tried again on what they did, but why they did it. That is based on Ahmaud's race and color. Here to discuss all of the action from court today, my legal experts, starting with veteran prosecutor and BNC legal contributor Paul Henderson and jury consultant Robert Swafford. Good to see you both. All right, guys, first things first, the jury, right, which is certainly more diverse than the mostly white jury from the state trial. Now, there's always an interest in the racial makeup of a jury, but it seems to matter more in this trial because it'll deal directly with the issue of race. Paul, with that in mind, what are your thoughts on the jury going into the evidence portion of this trial?
You know, what stands out to me is that in this trial, during this jury selection, we did not have the overtly racial kicking off of the black and racially mixed jurors. So we didn't have a lot of that action there. And I think that that was purposeful because that was an indication to the rest of the jurors how the defense counsel were going to approach race in the first place. So in this case, we do have a little bit broader diversity than we had in the first place. And I think that's purposeful, and I think it's intentional. And certainly it makes a difference when we're talking about looking at a jury that's going to have to evaluate whether or not race was the cause of why this crime and why this murder was committed. Of course, we all believe that to be the case already. And it does make a difference, I think, when you have jurors that have a broader familiarity of race based on their own life experiences that they don't have to hear about third hand or second hand as they try and evaluate the facts in the case. So yes, it does make a difference. And I'm grateful to see a different approach from defense counsel in the selection of this jury.
Robert, the prosecution strategy in the state trial purposely kept out the issue of race. Here, the issue is critical to making the government's case. Your thoughts, please.
Well, I think you know, in every situation, a prosecutor is trying to craft the message that will be that will be most receptive, that will have the most receptive audience. And you know, they've already done what they could to try to have an audience that's more receptive to the message through the jury selection process. But once you have those filters in place, then you have to craft the message. Now, I think they obviously made the right decision in the state case, because with the audience that they had, that wasn't going to be as good a message as, hey, listen, you know, this shouldn't happen to anybody, right? But in this situation, it's an element of the offense. They actually have to address it. They have to get that box checked off at the end. Otherwise, you don't have a guilty verdict. So you can't dodge it. But given the makeup of the jury, I think this particular jury is going to be more receptive to the audience. And I just want to say one thing about the fact that it's not only having people who have the lived experience of being black on the jury, it also affects the white jurors, because there are certain things that you're just not going to say that you might say if there weren't black people in the room.
All right, now to those opening statements. Bobby Bernstein, a lawyer with the Justice Department, told jurors flat out that the evidence in this case will prove that had Ahmaud been white, jogging through the neighborhood, who stopped to check out a house under construction, that he would have made it home for dinner. And to back up this claim, Bernstein repeated racial epithets all 3 men have said about black people. Paul, put this into context for why this is so important, not just for the prosecution to prove its case.
Well, it is, because, and I thought this was masterfully done, a very strong opening statement and very clear for the jury about where they thought prosecution, how their version from the prosecution about what they thought was important, how he articulated that but for race, we would not be here. But for race, Ahmaud Arbery would not be dead. But for race, he would not have been killed in the way that he was killed. I thought that was a fantastic presentation that framed the issues for the jury to understand from the very beginning what kind of evidence they're going to be hearing and why it's going to shine a light on the actions of the defendants to make it clear that they acted, that they were motivated by, that they were inspired by, that they reacted to the issue of race. And you're going to hear that again and again from the prosecution, just like most of the defense is going to be targeted around avoiding race, avoiding association with race, trying to talk about anything other than race, because they know that the more that they address, embrace, or and at least talk about race, it's going to be attributed to bad actions by their defendants, by their clients who have already been proven guilty in the state level. So I thought it was a strong opening.
Robert, the issue of race is generally uncomfortable for jurors, specifically white jurors, which was one of the reasons why the prosecutors in the state trial chose not to go there with the majority white jury. Again, here, the majority of the jury here is white, but this time prosecutors have to go there. Can that backfire?
I really don't think that it can in this particular context. And I think the word that he used, I think is a really good word, is framing. So there are two things that you're doing whenever you're doing an opening statement. So the rules say is that an opening statement is a brief statement of what you think the facts are going to be. So that's one thing that's happening, is you're going to outline what the facts are that you intend to present during the case. But the other thing that you're doing is you're creating a narrative or a frame or a way of looking at this, so that you'll get where you need to be at the end of the case, which is to have yes to the answers of was this a hate crime, right? And so I want to pick up on what our other guest said, is that framing is very important, and they did an excellent job of that.
All right, guys, in their opening statements, lawyers for Gregory McMichael and Travis McMichael obviously argued that racism wasn't at the heart of what happened on the day Ahmaud was murdered. For Gregory McMichael, his attorney argued that he had probable cause for his actions based on his knowledge of recent neighborhood thefts and a video of Ahmaud in that home that was under construction, that he didn't chase Ahmaud because he was a black man, but because he was the man. Paul, we know probable cause is a low threshold of proof, but was Gregory McMichael's knowledge of what he thought he knew enough?
No, it was not. The lies, the lies, the lies, because we all saw and heard the evidence from the first trial. They didn't have anything then. They don't have anything now. All they have is smoke and mirrors to try and take the conversation away from race. The nerve for this argument to be that race had nothing to do with it, I think they would have had a little more credibility had they said that race was an issue, but that was not what was motivating them, and they had all of these other reasons. But by starting off here was that race had nothing to do with it, I don't know how they're going to keep up that argument throughout the entirety of this trial when, but for race, they would not have had this collective action by all of these individuals acting collaboratively. They would not have had the use of the N-word. They would not have had the disparaging comments made about Black people. How do you get away from all of those facts that are coming out into this trial, let alone the video that we've already seen? I think that was overstepping their argument, and I think that they've gone too far, and it's going to be very difficult for them to maintain the framework of that argument, which they started off with which was race had nothing to do with this case. I think that's ludicrous. I think the fact that we have Black jurors on that jury, I think the fact that we have smart people or reasonable people on that jury, they're going to reject that argument flat out early on in the trial. And I believe that was a misstep from the defense. I think they should have balanced their statements a little bit better, because what they came out with was ridiculous based on what I know the evidence to be and what we have seen on the video and what their own statements and actions have been from the previous case. So we'll just see where they go from here, but I was disappointed with that beginning.
Robert, Travis McMichael's attorney, like the other defense lawyers, acknowledged the racist language used by her client. Words like animals, monkeys, subhuman, savages, just some of the words used to describe black people, but asked the jury to consider the context of this racism and consider whether the racist comments were connected to any specific acts against Ahmaud. Robert, jurors aren't lawyers and they can't compartmentalize like we can. How difficult will this be for the jury to do?
Well, you know, when you're a criminal defense lawyer, sometimes your job is to find some argument to make. You know, the criminal defense lawyer's job is to zealously represent their client, and there are sometimes where the facts just don't give you a lot of room or a lot of good arguments to make. So I don't think it's going to be very effective. I think it's something that just sort of, you know, belies credulity. That you know, and the thing is you're exactly right that whenever a lawyer is trying to make a very technical argument, you know, for example, if a lawyer tries to make the argument, well, the person, you know, may have been a prostitute, but she wasn't committing an act of prostitution on that day because she knew he was a cop, you know, which would actually be a good legal argument, right? But it wouldn't be an argument that would be particularly effective to a jury. So a jury's not going to care that much if you prove that these people are making racist statements and engaging in racist acts. They're probably not going to get a scalpel out and be able to say, okay, the prosecution hasn't linked these particular things together, and so we're finding them not guilty.